And we are live. Welcome to Crypto Law TV. I'm John Deaton, the founder and your host. Well, the hottest topic was Judge Torres's recent ruling and order, and except it got a little hijacked because of this ETF news that's going around. Is it real? Was it filed by BlackRock? Was it not filed by BlackRock? Listen, I don't worry about it because I wasn't going to sell my XRP or one way or the other. So I know it's the hottest topic. I'm really not going to comment. I know there's a lot of people out there disagreeing whether it's fake or not fake and why is it still on the site and all of those things. But today, if we put that aside, the biggest news in the Ripple case is that the judge issued her scheduling order for the final stage of the trial and the case. And let's put her order up so everybody can see it. All right, now, as you can see, she has set for February 12th, remedies related discovery is to be complete. All right, and then March 13th, the SEC issues their brief where they ask the court exactly what they want Ripple to pay, and then Ripple's opposition will be filed on April 12th, and then on April 29th, the SEC would be able to reply to Ripple's opposition. So that's the scheduling. The final brief would be, unless Ripple's allowed a cert reply, the final brief will be April 29th. Usually you can anticipate a ruling. It's safe to say 90 days. It could be 60, but let's assume 90, which is going to put us in the July time frame. So summer of next year, we're going to know exactly what the final judgment is. Again, this is only Ripple. Brad Garlinghouse, Chris Larson out of the picture. Cases are dismissed. It's only a charge against Ripple. Now, February 12th, what she means by remedies related discovery is the SEC has to frame what they believe is the appropriate fine and damages that Ripple must pay. Now, the judge issued a decision that said 770 million of institutional sales were violations of Section 5, that they involved the unregistered securities, which were these XRP transactions to institutions. And those sales total $770 million. And so there's going to be depositions or written discovery of certain people between now and February 12th. And then when that's done, the SEC will come out and say, hey, we want $1 billion. We want $500 million. We want whatever the number is. And so, and then Ripple will reply to that. Obviously, we're going to talk about what that actually is going to look like. Is Ripple actually going to pay $770 million or more dollars? And the answer is, in my opinion, absolutely not. And that's what we're going to explain. And so let me put up something to tell you what's in play here. How does the court come to what, in fact, are the appropriate damages? The first thing that you must remember is that this isn't FTX. This isn't Alex Machinsky and Celsius. There's no fraud. So we don't punish, right? When you commit fraud, the goal is to punish the wrongdoer for being fraudulent, for deception, misrepresentation, lying, and all of that. That's not the goal here. So first thing to think about is that premise. The premise is, what is an appropriate remedy when a company made some sales and they just did not make disclosures? They didn't disclose properly and make this registration requirement. right? It's something that's called more like strict liability, no evil intent, no bad will. They just didn't check a box, sort of the legal box, so to speak. So we're not out to punish Ripple. And that's how the judge is going to be coming to it. And so how do you frame it? And so we have case law that proves that. The first thing I'll bring up is the case in 2020 called Liu versus SEC. And I'll show you the holding here. And this involved a disgorgement action for the SEC. And you can see at the bottom is basically the gist of it all. And that is a disgorgement award must not exceed a wrongdoer's net profits and must, and I'm putting an emphasis on that, people, must be awarded for victims. Okay, so you've got net profits, not gross sales, not gross revenue. That's concept number one. And number two, that there's a victim, right? That there's victim here, that the victim has lost something. They've been victimized somehow. Some kind of pecuniary, excuse me, I made myself laugh. Pecuniary damages, compensatory damages, damages where they lost money. Okay, and so we're going to talk about that in a minute. Now, in addition, very recently, a case came down that Stuart Alderodi made a big deal about, and he tweeted it out. Here it is. Another loss this week for the SEC. The streak continues. The Second Circuit. Now, that's the circuit that Ripple's case is in. And SEC gobbles held that the SEC can't ask for a crippling disgorgement without first proving that investors suffered actual financial harm. In other words, no harm, no foul. What's Stu getting at here? It's what I said before in that first quote from the Supreme Court, where I said emphasis on must be for victims. And so we're not out to punish Ripple. We're out to an appropriate remedy that is to net profits. If someone profited from something and there was a victim involved because you cost them money, that's the whole thing. Now, so that is a case in the Govo. So I'll put out the Govo conclusion is basically right there. All right. And you can read it for yourself. But the Second Circuit vacated the district court and basically said that it must be some harm. Investors must suffer harm. Okay, so now you have the case law that is out before you. But before we get there, there's one more case law to know about, because we've got net profit harm, where you got to actually show economic loss to the victims. And now I'm going to show you what Jeremy Hogan tweeted out. He tweeted out basically a case called Morrison. And you don't have to read it there. I just want to tell you where it comes from. That's from the United States Supreme Court as well. And that case was cited quite a bit in the briefing. So what that case says is that the SEC only has jurisdiction over U.S.-based sales. Okay, U.S.-based sales. Now, imagine this. Brad Garlinghouse and Chris Larson, in their briefs early in the case, pointed out that 95% of Brad Garlinghouse's XRP sales were made outside of the United States. They were made in the UK, where XRP is not a security. They were made in Japan, where XRP is not a security, or it could have been Singapore, or it could have been anywhere else. That means what the Ripple lawyers, Brad Garlinghouse's lawyers, were saying was, look, this $110, $150 million that they're saying that Brad Garlinghouse sold of XRP, 95% of that's outside the United States. All right. SEC, you don't have jurisdiction on that. So the question really is, the same applies to Ripple. Out of that 770 million, let's use that figure. Out of that 770 million, how many of those cells were made in the United States? If they were not, the SEC can't count them, period. So imagine if Ripple, the institution, was similar to Brad Garlinghouse's cells. Brad Garlinghouse's cells, 95% out of the US. If Ripple did that, then that 770 million figure, I did the math before it went live, knocks off 731 million. I'm not saying that that's the case, people. I'm just saying that it shows you how drastically that can come down. That would leave 39 million in XRP cells. If it's 90% that were outside the US, then you're talking 77 million. I don't know the number, so I can't tell you. All I can tell you is that there's no way that they were all in the United States. And so that number is going to come down significantly. And that's part of the discovery where the judge wants to know, where Ripple's going to be showing the SEC, look at all these cells that Ripple made. Look at all these cells outside of the United States, and then get that figure lower and lower and lower. Now, once you employ that Morrison case and you get that figure way, way low, then you have to say, well, let's cite that Govo case and the Liu case where you have to do net profits. So let's say the cells are 100 million in the United States. You get to deduct legitimate business expenses. I don't know the answer to this, but the first thing I thought of was, God, man, I know for tax purposes, your legal fees are legitimate business expenses. But can you imagine if Ripple was able to deduct their legal fees in fighting the SEC? I doubt if that can be deducted. I don't know the answer to that question. It just humors me to think about. And more experienced securities lawyers who does this every day, we can maybe reach out and ask one of them. But legitimate business expenses that furthered a legitimate business purpose, right? That comes off, that goes to the net profit issue. What if Ripple didn't have any net profits? We got to think about those kind of scenarios. And so then we finally get, once you get past the Morrison outside the United States and that figure comes way down, and then you take off legitimate business expenses, and then that already drastically reduced figure gets reduced even more. Now you have to ask yourself, it must be tied to an economic loss suffered. So what if those institutional sales of XRP, what if half of them, what if all of them were XRP under 50 cents, where we stand today? There's no harm. There's no economic harm. XRP is more. Okay, because I can assure you that those early institutional sales, quite a bit of them were well under where XRP is today. Could there be others? Also, I can imagine Ripple during discovery will argue, and in their brief will argue that temporary transactions, ODL, where they're only owned temporarily, that there was no economic harm in those transactions, and all those ODL cells get excluded. So that's a way. The ODL cells was always an issue for this ruling by Judge Torres. But when you come to the remedies section, if there was no economic harm to any of these ODL cells, then those ODL cells are not going to be part of the equation. And so the judge wouldn't even have to in any way reverse her ruling or say that she, retract anything related to ODL. It just doesn't get considered in the story. And so that's basically, where we're at. I don't know what the discovery is. I can't tell you those numbers. I can only tell you that I am very confident that it is drastically lower than what people are thinking. And I think what's going to happen, All right. And we're going to wrap up. But I think what's going to happen is the same thing in the library case, where at the end, when the SEC got a $130,000 fine. Now, I'm not saying that Ripple's will only be $130,000. I'm just saying in library, ultimately, the SEC bankrupted a company in a non-fraud case, spent millions of taxpayers' money, and got a $130,000 fine from a company that never committed a fraud, never lied, never misrepresented, never hid information, and cooperated. And so when we turn to the Ripple case, whatever the ultimate number is, when it will be less than what Ripple paid in attorney's fees. I'm going to make that prediction comfortably and confidently. I'll come back. I'll admit I'm wrong. I've done that before. I'll do it again. If I'm wrong, I'll get back on live stream and I'll say, hey, got it wrong. But I'm going to predict that Ripple's $150 million in legal fees, that they won't have to pay that much. And it's going to make everybody sit back. Even the people that are against Ripple or they're not Ripple fans are going to sit back and say, my God, are you telling me, let's say Ripple pays $10 million, all right? Just pick a number. Let's say it's 20 million. Are we going to say that 3 years of extensive litigation, hundreds and hundreds of millions of dollars, lawsuits from retail investors against the SEC, all the damage that's been done on this case, and that's ultimately what Ripple pays, a fraction of what they end up paying to defend themselves, while Sam Bankman-Fried was running rampant, while Alex Machinsky was running rampant, while the Voyagers, the BlockFis, and everything else that was transpiring in crypto, where we needed the SEC, where we needed a cop on the beat to actually protect investors. While all that was happening, this is what they were doing. The libraries and the Ripples of the world. It will disgust most people, I believe. And even someone who isn't in crypto will sit there and be like, wow, you went through all of that just for that result? That seems like a colossal waste of resources and a diversion of attention on the wrong people, right? Instead of working against the bad guys, you focused on people who were trying to do it right. You claim they got a couple things wrong, and ultimately you accomplished what? And that's where we're going to end up with. And so basically, I hope it explains what we're headed and what this remedies section is going to look like. Next week, there won't be a live stream. Hope everyone has an incredible, wonderful Thanksgiving. I know I'm thankful for all of you out there, and see you in a couple weeks.